I'm counsel for Hobby Lobby. I'm part of a terrific team who has been fighting this case for the last 2 years and won at the Supreme Court today. The Supreme Court today decided that Americans do not give up their religious freedom when they open a family business. The court's decision was narrow and careful. They did not apply this to all manner of corporations, including large publicly traded companies. They really limited it to closely held corporations. From there, they found that this was a substantial burden on the Green family's religious exercise to put them to this choice, and that the government couldn't justify that burden because the government had a lot of other ways to achieve its goals that did not involve trampling on the Greens' religious freedom. It is the government's responsibility to look at alternative means and to prove why it could not do anything else. Here, the government had the option of just providing these objective contraceptives directly. They could have paid for them directly. The government already spends $300 million a year on Title X specifically to provide contraceptive services to women, so it's hard to argue the government doesn't have any other way to do this. The government also set up an accommodation scheme for nonprofits. Now that is currently being challenged by groups like the Little Sisters of the Poor. But the fact that the government has said we have other ways of reaching this goal made it pretty clear that they could not trample on the Green family's religious freedom. I think this is an incredibly important case. It shows us that the Religious Freedom Restoration Act is alive and well. This was a law that Congress passed overwhelmingly 20 years ago. It had broad bipartisan support. It's been challenged several times. The last 2 times it's been up before the court, it has won decisively. We think that this decision is narrowly focused. The majority opinion is careful to say that this is not going to cover all kinds of claims. It will take those cases as it comes. 8 years ago, in the Ocentro case, the Supreme Court carved out a religious exemption from our nation's drug laws. And at that time, the Bush administration said, you can't do this, the sky will fall. Well, the sky hasn't fallen. There have been only 2 religious exemptions made based on the unanimous Ocentro case. And so I can't imagine that we will see some sort of extreme results or extreme consequences flowing from Hobby Lobby. Well, the Supreme Court did what the en banc 10th Circuit did, which was recognize the Green family did have religious freedom. They could continue to exercise it. This was a burden on that freedom. The lower court had decided that they had given up their religious freedom in effect when they had opened Hobby Lobby and incorporated that business. And I'm glad to see that the Supreme Court disagreed with that today. Well, what's next is Eternal Word Television Network. They're asking the Supreme Court for emergency relief today. We've also got cases like the Little Sisters of the Poor that involve nonprofit ministries who are challenging this same mandate. We expect that will probably be back before the Supreme Court next term.